democratic republic, parliamentary democracy, and the three organs of the state certainly constitute the basic structure. In the sense in which sovereign democratic republic is understood, it cannot be said that the structure of the Constitution as an organic instrument establishing sovereign democratic republic as envisaged in the preamble will remain the same if Part L 2 and IV or either of them are totally abrogated. 2017-518 T. Object of the fundamental rights is to ensure the ideal of political democracy and prevent authoritarian rule, while the object of the directive principles of state policy is to establish a welfare state where there is economic and social freedom, without which political democracy has no meaning. What is implicit in the Constitution is that there is a duty on the courts to interpret Constitution and the laws to further the directive principles, which under Article 37 are fundamental in the governance of the country. To say that the directive principles give a directive to take away fundamental rights seems a contradiction in terms. There is no rationale in the argument that the directive principles can only be given CFFTCT2 if fundamental Righu arc abrogated, the interest to CF, the community, and of the he. Society can be adjusted without abrogating, damaging, emasculating, or destroying the fundamental rights in such a way. 11 to AMO. Plenty to abrogation of these Righu. The guarantee in Clause 4 of Article 32 could be conceived of only against amending power. For no ordinary law can suspend a right given by the Constitution unless permitted by the Constitution itself. When Clause 4 of Article 32 does 11 even permit suspension of the right under Article 32, except as otherwise provided in the Constitution, that is, by Article 359, it is highly unthinkable that by an amendment this right could be abrogated. This pivotal feature of the fundamental rights demonstrates that this basic structure cannot be damaged or destroyed. When a remedy cannot be abrogated, it should follow that the fundamental rights cannot be abrogated for the reason that the existence of a remedy would be meaningless without the Righu. Kesavananda Bharati 39 Sectern 2 of 25th Amendmenta. I'd ever since the Constitution, 4th Amendment Act this court had con. Sistendi held that where what I given in lieu of expropriating property of a citizen is illusory, arbitrary, or cannot be regarded as compugnation, and bears no reasonable relation to the property acquired, the Crown can go into it. And secondly, where principles are jixed for determining the compensation, it can examine the question whether they are relevant to the object matter and if the acquiescence. Click position has not in any way been ALFCTTCD by the Amendment B1, merely MB instituting the word amount for compensation. If the amount is illusory or arbitrary and is such that it shocks the conscience of any reasonable man and bears no reasonable relation to the value of the property acquired, the court is not precluded from amending it, the legisli. Even in cases where a Jixtian amount for the acquisition or requisition of a property must be presumed to have fixed it on some basis or applied some criteria or principles to determine the amount so fixed, and therefore, where the law is challenged on the ground of arbitrariness, illusoriness, or of having been based on irrelevant principles or any other ground that may be open to challenge by an expropriated owner, the court will have to go into these questions. This will be so even in respect to the manner of payment. P. 523-524J Clause 2b provides that nothing in sub E. Clause F of Clause 1 of Article 19 shall affect any ouch law as is referred to. Clause 2 docs this mean that the fundamental riglet to reasonable restriction of procedurral nature under Article 19L F available is abrogated, or destroy CDL. The answer to this would depend upon what is the meaning to be given to the word effect. Two constructions are possible. One is that Article 19.1 F will not be available at all to an expropriated owner under a lawful acquisition made under Article 31.2. Secondly, see all. 2b is intended to provide that the law of acquisition or requisition will not be void on the ground that it abridges or affects the right under Article 19.1. The second construction is more in consonance with the amendment, because what the amendment provides for is that Article 19.1 shall not affect any such law, and this would imply that the bar against the application of Article 19LF to ouch a jaw may vary from a slight or partial encroachment to total prohibition or inapplicability. But since an AMC 11 DMCNT cannot totally abrogate a fundamental right, It can only be read BV the adoption of the doctrine of severability and application, and accordingly clause 2b must be held to be restricted only to the abridgment of, as distinct from abrogation, destroying, or